Stephen, estate planning means something very different when someone has real accumulated wealth, a business, investment properties, a professional practice, a large retirement portfolio. Where does the complexity actually begin to shift?
Basically, for all those reasons, if you do have a small business or as you accumulate more investment property or accumulate more assets, the complexity grows with that because then you have a lot of different factors that we take into account into drawing up the estate plan to meet the client's individual needs to meet what their family estate planning goals are.
The Space Coast has a distinct kind of high net worth client: aerospace engineers, Kennedy Space Center contractors, physicians, developers. When these folks walk in, what are the most common planning gaps you find that a basic will and power of attorney package completely misses?
Have a lot of assets at that point, and they may have some rental properties or things like that. So they're missing proper asset protection techniques that may come into play, such as limited liability companies or irrevocable trust. Or in that situation, if they come with a basic will package, that means that they may have not considered what probate would mean if they were to pass away. So the definition of probate is proving a will. So if you have a will-based package of estate plan documents, that means that when you pass away, assets that are titled in your individual name are going to go through probate before it passes to your loved ones.
Will, revocable trust, durable power of attorney, healthcare surrogate, living will. For high net worth individuals specifically, what does each one protect, and which of those five is most commonly underpowered or missing entirely?
So let's start with the basic three, which is the advanced directives or power of attorney, healthcare surrogate, living will. So each of these is the living will is you saying from beyond. If I'm in an end stage condition and there is no chance of recovery, and two doctors have certified that there's no chance of recovery, then that's you saying from beyond, please just let me go. So it saves your loved ones the very difficult decision to make that final determination. Um, Healthcare surrogate and power of attorney, those are similar in that those are normally utilized when you're incapacitated, dementia, stroke, something like those lines. And you've designated the person, and then we want a backup, and then a backup to the backup to make sure that you have designated people to make either healthcare decisions for you under healthcare surrogate or financial and legal decisions for you under power of attorney. So the importance of those documents specifically is to avoid what's called a guardianship. Guardianships are very expensive. They're very complex. You have to have two attorneys involved. And you also have a doctor, nurse, and social worker who assess the incapacity and then they make a report. And so they have their hands out. The two attorneys have their hands out. The county has their hands out every year because you have to file an annual accounting every year with the guardianship. And so it's a very, very expensive, lengthy um, process to go through. But what make it even worse is that the person who becomes the guardian may be the last person in the world who you want to make decisions for you. But having the power of attorney, having the healthcare surrogate in place gives you a better chance of being in control a lot longer because you've designated who those people are. So then we go with the will and the trust. So both are equally good at determining where you want your assets to go, to whom you want, when you want, the way you want it to when you pass away. But the big difference is probate. So have a revocable trust that's funded helps you avoid that probate process that here in Florida is very expensive and lengthy to go through.
A Brevard County investor owns several rental properties. Walk us through the logic of how you'd structure that portfolio for both estate planning and liability protection simultaneously. What goes in an LLC, what goes in a trust, and why?
A lot of times with that sort of structure, the conversation is going to be the complexity of a number of LLCs versus stronger asset protection. Okay. So think of it as their LLCs are bubbles. And inside the bubble, you want to put in the rental properties. Okay. So what that does is that makes sure that whatever happens in those rental properties can't get outside the bubble. If you put 3 houses inside that bubble, well, they can get to each other, okay? So, that's when we often have the conversation that for best protection, you wanna make sure that each, rental property has its own bubble. So, that means that makes sure that each of those rental properties are not subject to something happening at one of the other rental properties. Some clients say, well, that's too much. I have 9 rental properties. I don't want 9 LLCs. I don't want 9 schedules on my tax return. I don't want 9 annual reports. So then we have the discussion, okay, what is your comfort level of having separate LLCs, but with the knowledge that if you combine houses into one bubble, they may be able to get to, if something happens at one rental property, you can get to those inside the bubble. Now, the trust strategy is could be twofold. One, it could be we could utilize an irrevocable trust in order to hold that membership interest. So let's say you're a single person and you want to make sure that you don't want a partner. You don't want another member in there. So you just want it as a single member, but you want the asset protection. If we put that membership interest into a certain irrevocable trust, then if that single member has a car accident, the creditor can't touch everything that they work for with the rental properties. Okay. Now, it could be that's a married couple, and we want to ensure that maybe we just utilize a revocable trust for those purposes because of the fact that now we at least have 2 members and we can structure it where it's tenants held as tenants by the entirety. But sometimes married couples have a joint liability. So if we want to enhance that protection even more, we may want to create an irrevocable trust for the kids as that third member. So that ensures that no matter what happens, they still have that multi-member protection, which limits a creditor to only a charging order remedy, which means they can only attack distributions as it comes out of the LLC, but can't get the actual membership interest like they could with a single member LLC.
The golden rule in asset protection is you cannot move assets after a claim arises. What does that mean practically? And what is the most dangerous version of too late you've seen a client come in with?
Even when there is a claim arises, there isn't some things that you can do. You can still buy a homestead. You can still upgrade your homestead. You can put money into your homestead. You can pay down mortgages. You can buy an annuity. There's still things that you can do even pretty much at the doorstep of the sheriff coming to your door. But don't take that lightly. Don't just go and do that. You need to make sure that you meet with an asset protection attorney in order to determine what's the right thing to do and how to do that. So there's never really a too late, but your options are much, much more limited. Okay. So if you think of asset protection and this fraudulent transfer, which is what we're worried about, as a pendulum. So over to the left, where it's very safe, is that when there's no claims, everything is good. You have all the abilities to be able to satisfy any of your outstanding obligations. Then it starts to swing when trouble arises, maybe get into a car accident, but you believe that your insurance should fully cover the other automobile and its occupant. Then you still have some opportunity to make some changes if you need to make them. But then as the pendulum swings and it gets more to, okay, now there's been a lawsuit. Now there's a judgment. Now they're trying to pursue the judgment. That's when it gets closer and closer and closer to that fraudulent transfer, which is what you want to avoid. Fraudulent transfer means the judge says, you purposely moved assets to frustrate the creditor, and I'm going to claw those back. I'm going to undo those things. Okay. So, um, and failure to do what the judge says could mean that you're held in contempt, which means you could be in jail. It could be some stronger financial ramifications to it. Okay. So the best time to plan is when everything is good and there's no kind of trouble on the horizon. As it swings further and further towards trouble and then maybe that there's a creditor and a judgment against you, that's when it gets closer and closer to that fraudulent transfer, which is what you want to avoid.